Welcome to an oral argument session of the 5th District Court of Appeal. I'm Jay Cohen, and I'll be presiding this morning. I'm honored to sit this morning with Judge Dan Traver and Associate Judge Letty Marquez. The first case that we have on the docket is Smithy, or if I'm pronouncing that incorrectly, Mr. Offerman, let me know, versus State. Remember that this is being recorded on YouTube. We probably get millions of hits on our oral arguments. As best you can, try not to interrupt each other. Remember, it's not a presidential debate. And so if you could just keep your microphones on mute until you're ready to speak, that should work out fairly well. Each side will get up to 20 minutes for their oral argument. I have a default set at 5 minutes for rebuttal. If you'd like something different, just let me know. I'll be glad to accommodate any requests that you have. So that said, Mr. Offerman, you may proceed, sir.
Good morning. May it please the court. Michael Offerman on behalf of the appellant Anita Smithy, and I would like to reserve 5 minutes of my time for rebuttal. I'll focus my time this morning on the first claim raised in the briefs, and that is whether my client received ineffective assistance of counsel when her attorneys opened the door to otherwise inadmissible and extremely prejudicial evidence at trial.
Let me, Mr. Offerman, start with this. Do you think that we look at the totality of the representation, or do we look at one incident that occurred that in terms of the admission of the 911 call? Because I think you would probably concede that Mr. Jansha had done a good job. He got a warrant suppressed or found to be invalid. He got the statements suppressed, and he got a series of rulings that were quite favorable in terms of whether he had opened the door in his cross-examination. He was apparently very careful on that. So would we look at the totality of the circumstances? Because I don't think anyone's entitled to a perfect trial, are they?
No, but I don't believe you look at the totality of the circumstances either. And I don't disagree that he did other good things in the case, but it only takes one error to amount to ineffectiveness, especially when that error, such as the error in this case, leads to the introduction of otherwise inadmissible evidence. Again, but for the decision to introduce the 911 call, especially since he didn't know the law and understand that that would open the door, that alone amounts to ineffectiveness that deprived my client of her Sixth Amendment right to effective assistance of counsel. So my client was charged with second-degree murder. It's from an incident that occurred during the early morning hours of March 4th, where she shot her estranged husband. The record is clear that he was not supposed to be there on that evening. She had moved out of the marital home 3 months earlier to get away from him.
That the record's clear on that. I mean, there had been a series of occasions where he had come over for recreational activities, and they had a phone call, a lengthy phone call earlier in that day. There was no sign of forced entry, so I'm not necessarily buying that he wasn't supposed to be there. We know that they had consensual sex the evening of the shooting.
Let me restate this way, Your Honor. The evidence, or the defense at trial, was self-defense, and certainly there was evidence that supported my client's theory. And the best evidence in what I was just referring to was there was text messages just before Mr. Klein came to my client's residence, and he specifically asked, "Can I come over?" And she said no. So the last communication from her prior to him being in the home is that she said, "Please don't come over," or "You're not allowed to come over," and he came nevertheless. You are correct, Your Honor, that in the months after they had broken up, my client acknowledged that they had engaged in certain occasions in consensual sex. She even acknowledged that after he was there on this evening, she wanted to placate him and have him leave. So she engaged initially in one instance of consensual sex. But after that was over, she said that she asked him to leave, and he refused to leave. And in fact, she said he became enraged, apparently jealous that she was seeing someone else. And that's when he brutally assaulted her a second time, the second time without her consent. And it was at that moment that she shot him, resulting in his death.
Let me get directly to the 911 call. The significance, of course, was that in that call, she had made a statement that he had stabbed her.
Correct.
And that was contradictory to admissions that she had made to law enforcement that she had stabbed herself.
Correct.
But wasn't the evidence already before the jury that her wounds were self-inflicted through the medical examiner?
There was conflicting evidence, Your Honor. So the state did put on the test.
Government, that wasn't my question. The fact the jury made a determination here, so the jury believed, one side of this case, and you have to take the evidence in the light most favorable to the state. So, you had testimony from the medical examiner that the wounds were self-inflicted.
Yes, Your Honor, but I respectfully disagree that I have to take the testimony in the light most favorable to the state. That's a judgment of acquittal standard that would apply. But for our purposes, the defense was arguing that these were not self-inflicted wounds. And so most importantly, going to your point, yes, the state put on Dr. Bullock, who said that these were self-inflicted wounds. He also said, to my client's credit, to support her theory of defense, that he could not rule out that this was sexual assault. But in response to Dr. Bullock's testimony, and this leads right into why counsel was so ineffective in doing what they were doing, is that the defense put on Dr. Anderson. And Dr. Anderson responded specifically to Dr. Bullock's testimony and said, in my medical opinion, her wounds were not self-inflicted. So that was there was a conflict in the testimony that the jury was free to resolve that conflict, but that was wiped out.
On cross-examination, though, he walked back on that opinion somewhat.
Maybe somewhat, but ultimately his opinion was still that she had not self-inflicted her wounds. So yes, the state tried to cross-examine him, but the defense was nevertheless presenting his testimony to refute Dr. Bullock's testimony to show that she did not self-inflict her wounds. But most importantly, and this is why this matters for ineffectiveness, if you ever thought it was even possible that the jury was going to hear the statements that you tried so hard pre-trial to keep out, you would never put on Dr. Anderson in direct examination to tell the jury that no, she did not self-inflict her wounds. Because again, that was one of the last pieces of evidence, but the last piece of evidence that the jury heard. So after that was presented, and then the defense was getting ready to rest, the last thing the defense did was say, Your Honor, we're now going to present the defendant's 911 call. The state didn't object because they knew exactly what was getting ready to happen. The 911 call was played. My client said to the 911 operator, he stabbed me, and the state immediately moved for a sidebar, and at sidebar they argued the door has now been opened for us to introduce the otherwise inadmissible statements, the statements that the defense went out of their way to suppress pre-trial, that the judge specifically ruled that she did invoke her right to remain silent, and therefore the state could play everything up until—
Counsel, would you agree with me that if the defense does not call Dr. Anderson, that your case doesn't have nearly as much merit, if any? In other words, is Anderson, that decision to call Anderson and then play the 911 call, that's of critical importance here, correct?
It matters, but I think we're kind of mixing things. I think we have to look at ineffectiveness and prejudice. The presenting Dr. Anderson and having the jury believe that the wool had been pulled over their eyes, and then only to hear from my client that she did in fact self-inflict her wounds, which the jury would be wondering, why did you present a doctor to tell us that she didn't self-inflict her wounds when you knew all along that she did? That shows how prejudicial this is. But I need to back up because we need to get to whether defense counsel was ineffective. And I think—
Well, then let me ask my question a better way, because I don't necessarily know I did as good a job with that as I could. If they don't call Anderson, is playing the 911 call ineffective?
Yes.
Why?
Because they specifically said it was their strategy pre-trial to keep out her statements that she self-inflicted her wounds. If they were going to allow why would you file a motion to suppress her statements, to keep them out, go out of your way to argue that, and then have the judge rule in your favor to then turn around and do something that would cause those statements to be played for the jury?
Well, I think a reasonable answer to that question would be that trial wasn't going very well. That was certainly
not what Mr. Bellinger said.
Do you mind if I finish?
Sure, of course, Your Honor.
The trial court, in what I thought was actually a pretty decently worded and coherent order, basically opined that the chance of guilt was high after the state closed its case. And that theoretically a defense argument might have been, what do we have to lose? And we make strategy changes all the time in midstream based on how things are actually going in the middle of a trial, as opposed to how we presume they're going to go beforehand.
Your Honor, we don't have to guess what the strategy was. So if the trial court had made that finding after either Mr. Bellinger or Mr. Jancha testifying that we didn't think we were doing well, and therefore we decided to do something that would cause her statements to be introduced and then tried to use those to our advantage, I would have a hard time responding to that. But what is the evidence we have in this record? We have one piece of evidence. It's on page 733 of the record. It's Mr. Jancha's affidavit. This was introduced during the evidentiary hearing because he was unavailable, and the parties agreed that this was introduced as substantive evidence as to what he would have testified to had he actually testified at the evidentiary hearing. He says two things that are extremely important. Number one, paragraph 5. At the time I introduced the 911 recording, I did not realize that playing the 911 recording would open the door to the previously suppressed statements. Number two, it's extremely important, completely overlooked by the trial court. Although the 911 recording was helpful, it was not necessary for the defense to win. So what was counsel ineffective? In Butler, this court specifically said, a tactical or strategic decision is unreasonable if it is based on a failure to understand the law. If at the time Mr. Jancha introduced—
Mr. Ufferman, excuse me. Mr. Ufferman, throughout this transcript and the record, it is very obvious that these two attorneys knew the law and argued it quite effectively several times to keep out the suppressed statements. Why should this court believe that they suddenly forgot the law when it came to the introduction of the 911 call?
Your Honor, because he said it. I don't know how to get around this. This isn't something that's in dispute. The state didn't put on anything to refute this affidavit. This affidavit is the evidence in the record. And he specifically said, and Mr. Bellinger repeated it, we didn't realize, we didn't know that introducing her 911 call would open the door. So,
but didn't Bellinger say that the reason he didn't know it is because he didn't remember that she had made the statement that she stabbed herself?
Yeah, even more ineffectiveness on his part. The state tries to put that off by saying, oh, he's only second chair, he's not lead counsel. But yes, if he didn't even realize that she had said during the 911 call, he stabbed me, clearly he couldn't make an informed decision as to whether or not introducing the 911 call would open the door. But back to Mr. Jancha, this is, and I'm arguing this, no reasonable attorney would not have understood that if the trial court has ruled pre-trial, her statement that I self-inflicted my wounds is not admissible in the state's case in chief, but the door could be open to that. And then if the defense is going to introduce evidence that she said he stabbed me, no reasonable attorney would not understand that that is definitely opened the door to her otherwise inadmissible statements that she stabbed herself. I cited to the Madison case from the first DCA, and this is every single district has repeated the same conclusion. The concept of opening the door is used to negate the misleading impression given by defense counsel's questioning. Defense counsel in this case put in the misleading impression that he stabbed me. Clearly, the state was going to immediately move to say that the door has been opened, and they did. So the prosecutor knew the law. The prosecutor knew right away that the moment the 911 call was played, that door had been opened.
But that same prosecutor had on 6 prior occasions argued the same thing unsuccessfully. So I'm not so sure, that makes a difference one way or the other. But what about the concept that the defense wanted the jury to hear her voice, and the only way that they could get that in front of the jury would be by the playing of the 911 tape? Could that constitute a reasonable strategic decision?
So I do need to respond back to the fact that 6 other times the state might have argued that the door was opened is irrelevant if the one time that the door is opened is when the defense actually presents her statement, he stabbed me. Again, everyone would understand that that's going to open the door to the otherwise inadmissible statements. the fact that the defense, again, Mr. Jancha said it was helpful for the jury to hear her voice, but let's look at what already came out during the trial. This idea that, oh, they needed to establish that she was hysterical. The testimony in the record clearly showed that she was hysterical. They presented the neighbor who said that Miss Smithy came knocking on her door, screaming as she was banging on the door. They played her 911 call. She said Miss Smithy came over here and she was frantic. That also referred to her testimony as being, or her demeanor as being hysterical.
It's one thing to hear it from witnesses, and I understand where you're going with that. It's another thing to hear it directly from the defendant, isn't it?
They did hear directly from the defendant. The state played hours of her interrogation where she explained her self-defense theory. The state was allowed to play her interrogation up until the point that the law enforcement had violated her right to remain silent. So they got to hear from her directly. They got to hear her specifically tell the jury, I acted in self-defense. So this wasn't an issue where they didn't get to hear from the defendant. This wasn't an issue that they didn't get to hear that she was frantic or hysterical at the time of the incident. All of those factors had already been established. So again, as Mr. Jancha said, it was helpful, but it was not necessary. But what was necessary, especially if you are going to put Dr. Anderson on, is that the jury never hears what had previously been suppressed. So the state mentions in their answer brief that on direct appeal, a friend of mine, Bill Parnell, who represented Ms. Smithy on direct appeal, raised a number of issues. You know what issue he didn't raise? He didn't argue at all that the door had not been opened, and Judge Lester got it wrong when he made that conclusion. Why didn't he make that argument? Because he couldn't, in good faith. It's clear cut that the moment the defense played this 911 call, the door had been opened. But what did he raise? He actually argued on direct. Your Honor, I think you're on mute. Your Honor, I think you're on mute. I'm sorry.
Sorry. Just to let you know that you're into your rebuttal time.
Thank you. Let me go for another minute and a half or so.
Mr. Offerman, you're simply going to have to learn to read lips.
I apologize. He did argue on direct appeal that this was ineffectiveness on the face of the record. Mr. Parnell knew at that point that any attorney introducing this 911 call, after going out of your way to keep it out, this was ineffectiveness. And again, we need, Mr. Bellinger's testimony explains he didn't even know factually what was in the 911 call. How could he possibly make a determination? And again, Mr. Jancha himself said he didn't offer some other strategy. He didn't say, I knew that there was a good chance that the door would be open, but the 911 call was so important to us that I was willing to take that chance. Maybe the judge doesn't say the door's open, maybe the judge does, but I still want the 911 call in. If he'd have said that, I'd have no argument. What did he say? I didn't know that presenting the 911 call would open the door. That's clear ineffectiveness. Regarding prejudice, again, I've made my 2 points in my briefs. I'll repeat them very quickly now. Number one, after you put on Dr. Anderson, how could you possibly turn around and expect the jury's going to believe anything you say when the jury now hears as the very last piece of evidence that she admits to law enforcement that she stabbed herself? And then even worse, the very last thing the jury heard in this case was the prosecutor's closing argument. And let me read it real quick. This is page 2144. And she was not justified and she knew it. And that's exactly why she cut herself. She inflicted those injuries to herself. And that's exactly why we submit to you that we've proven our case to you beyond a reasonable doubt. One sentence later, return a verdict of guilty. Thank you. Last words the prosecutor said in this case before the jury began to deliberate is find her guilty because she self-inflicted her wounds. And why did they hear that with certainty? It's not because Dr. Bullock was saying it. The prosecutor was able to say in closing several times, you heard it directly from her. She self-inflicted her wounds.
Give me just 15 seconds or 30 seconds on your second point.
I think we win based on the state of the record, but all of those things are further evidence that should have been considered. I think this court could consider it. Otherwise, it could be sent back for remand for reconsideration. But this is an admission by a party opponent regarding the 48 hours interview about how important this was and how a trap had been set by the prosecutor. Mr. Kessler's opinion about what a reasonable attorney would do in these circumstances when you know a judge has ruled pre-trial that statements are otherwise inadmissible, but the door can be opened. I cited to the Mathis case where the first DCA relied upon expert testimony to reach a conclusion. And then finally, Mr. Jancha's conclusion about what impact this had on the jury. Of course, that's something that attorneys should be able to give an opinion about. They're required to do it every single day when they advise their clients about the strengths of a state's case. So I think all of those things should have been considered as to whether or not there was ineffectiveness and prejudice. I'll reserve the rest of my time for rebuttal. Thank you.
All right, Mr. Coriante.
Thank you, Your Honor. May it please the court. I'm here representing the state of Florida, and we can start with Mr. Belager's testimony. The very end of his testimony in this proceeding, he said he still thinks the trial court was wrong in allowing, in opening the door, in ruling that the door was open.
Well, let's talk about that, a little bit.
All right.
First of all, I think that as has been acknowledged, the strategy of keeping out the admission was critical. And it appears clear to me, at least, that the admission of the 911 call, completely, eviscerated that strategy and ran, contrary to that strategy. Can you seriously argue that the admission of that 911 tape wouldn't have opened the door to admission of the earlier statement?
Well, he was willing to take that risk. And yes, I can argue it. I can argue it, Your Honor.
Right. Go ahead. Give me your best case for the proposition that the admission of that 911 tape didn't open the door to an inconsistent prior statement.
All right. We have to go back through, as we've already discussed, the other 6 times or 5 times that they tried to get in that very one
case. Give me the best case law that you've got to support that proposition.
What? Your Honor, it's
the only case that you cited in the brief for this proposition was the one where the gentleman who had mental illness was talking about aliens.
Right.
And clearly that wasn't offered for the truth of the matter asserted. There were no aliens there. This situation, is there a colorable argument that it was offered not for the truth of the matter asserted? I mean, the theory here seems like they wanted the jury to hear her hysterical voice, which would be different than the custodial interview. And that secondly, here was an opportunity for the defendant to get her theory of the case out in front of the jury in her own words without being cross-examined. So what is the colorable legal argument that this was not offered for the truth of the matter asserted?
Well, the legal argument, as the defense counsel stated, first of all, it wasn't even hearsay. It was a spontaneous statement. It was uttered in excitement at the time of the event. This was her 911 call. They're admitted all the time in trials. And they're an exception to the hearsay rule. On top of that, being not offered for the proposition.
I've taken evidence, but a spontaneous statement's an exception to hearsay. It's not non-hearsay. Am I wrong?
Oh, it's correct, but it's an exception to the hearsay rule, and therefore...
It is hearsay.
What?
You indicated it wasn't hearsay. It is hearsay.
Well, correct. It isn't hearsay in the same sense as far as how it's admitted. It can be admitted as an exception to the hearsay rule. I've said that as well. But
the difference is that a non-hearsay statement can't be impeached substantively.
Right.
And the hearsay statement, even if it falls under one of the exceptions, doesn't it fall under 9608 sub 1? Just the Huggins situation, for example, where it exposes a defendant to having their conviction history put into evidence. How, and again, I circle back, what's the most colorable legal argument, or to Judge Cohen's question, what's your best case as to how this didn't open the door?
Well, I mean, I don't have a case on point that says this set of facts doesn't open the door. It's just the argument based upon what went on, what the judge heard for 2 days in a hearing on this. And the judge had ruled 6 times previously that the hearsay didn't open the door. I can cite to pages where the exact statement had come out. And so this was a close call. The defense attorney stated, I still believe it was a wrong call. They didn't believe the judge was going to reverse and finally say, yes, this opened the door because of the previous rulings in the case. I believe that they thought it was necessary and it was worth the risk.
So let's summarize then. You have no case that supports that theory, and when Mr. Pinnell wrote his initial brief in the case, he had no case law that supported that theory. Correct?
I believe. I mean, I don't have his brief in front of me. But I do remember saying it was a 74-page brief, so there was a lot in there, and I know he did raise ineffective assistance of counsel. I recall that. But at the same time, everybody in the courtroom knew what was coming next, and the argument lasted overnight recess, and the very next day, they came in and argued for an hour as to why this should not open the door. And
wasn't that just a measure of how critical the admission of that statement was?
Well,
I mean, if I'm the trial judge in that particular case, I think I want to make sure that that evidentiary ruling is correct. But one thing that I noted is that you didn't cite any of the cases that Mr. Jancha raised in that hour in front of the judge. I wondered if that was a concession on your part that they didn't apply, or that the alien case was a better argument for you.
Well, no, it wasn't that. I thought that the record was clear. I didn't cite many of the facts that I cited in my initial brief on appeal and in other places, because the record here is voluminous, and this court has already heard the direct appeal, and everything is here in the record. If it's in the record, I'm going to assume this court will take it into account. I think that throughout that argument, they presented several reasons why it should not be admitted or open the door. And they ran that risk. They certainly knew. I mean, to rule any other way, you would have to determine that he had no idea it was on the tape. That's clearly incorrect, because they fought so hard to keep it out, as Mr. Ufferman mentioned. So he knows it's on the tape, and he knows he wants to enter that into evidence, and he makes a decision at the very end of his case. He brings in an expert to help.
His co-counsel didn't know what was on that tape. And so how do we know that Jancha knew that? Where's the record on that?
His co-counsel waffled on this, but I have it here that at the very beginning, the whole case, I don't know if I have the page cited, but they knew that they wanted to have this from the beginning of the case. They wanted to have their cake and eat it too. That was another expression he used. And there was no, he said, well, I may have listened to it sometimes and not heard it, which begs the question I mentioned in my brief, that he probably listened to it and then heard it. He waffled on that, but he never swayed from it was always Mr. Jancha's intention to get her voice in front of him.
If that's the case, though, why call Anderson at all?
Anderson,
if you know that you're going to conclude your case in front of the jury with the hysterical voice of your client saying that I stabbed myself well after I defended myself, and you know that that argument is going to be featured in the closing argument by both the state and the defense, why call Anderson at all? Because at least there's a colorable argument that you've just doomed yourself to failure, right? Because Anderson all of a sudden is going to be completely discredited by the client's own voice. And I think you have to at least be a little bit concerned that you lose your credibility with the jury as a defendant and as the lawyer representing that defendant. So to circle back to my initial question, if it was a full theory all the way through the life of the case, what is the reason for calling Anderson at all?
Anderson was critical to cast doubt on the statement made by Appellant here when they said her admission that she cut herself was not an outright admission. Her statement was,
Counsel.
yeah, I guess it must have happened.
Counsel, let me interrupt you, please.
Okay.
Counsel, if Anderson's testimony was critical, why would you put on the 911 tape to contradict Anderson's testimony?
It was to cast doubt on what she said in her statement that they probably knew was going to come in if they made that call. He would cast doubt on it because his testimony was that there's no way she could have inflicted her own wounds like that. And then she comes and her statement comes out and says, I guess
So
it happened that way.
You're
I'm not sure.
conceding that by putting in the 911, they probably knew that the suppressed statement was coming in?
I believe that there was a good chance it was part of their strategy based on Mr. Belanger's testimony from the outset of the case. They wanted to get that 911 tape in there. It's
You may
his
have already
testimony.
answered this, but why would you put on testimony that deliberately contradicts exactly what your expert just said and lets in all of the statements that you've spent the entire trial trying to keep out?
It was very limited what was let in, but it was to cast doubt on her one statement that they allowed in that said, maybe I cut myself, maybe not, is what it sounded like. And you have an expert saying she probably didn't. And you have her testimony, and all of this defense is that she was panicked, raped, attacked, and didn't know what she was doing and screaming. And that tape was the best evidence of that.
You think that's a reasonable defense strategy?
I do, Your Honor. I think that at that point, as the trial court ruled, this case was going strongly for the state. At the very end, when he decided to put that in, he made a calculated decision that what she's got to say is going to dissuade all of the evidence about her faking her tears, faking her injuries, all of the things that she did that made it look, her phone calls that she made to her friends, where she admitted she had this wild, crazy sex, and she admitted that she shouldn't have done it, and that maybe is an accident. But we have three different stories. We have a gun in a closet, in a bathroom, in a nightstand, and then snuck under a pillow for her to plan this. And she has all of this trouble, and she's doing it cold and calculated on the police tape and on the telephone calls. And he decided he needed to have that extra push because he was losing the case. It was agreed to by appellant, according to Mr. Belanger. And it was just a strategic trial attempt to get that in without getting it to open the door. Argued to the court. I don't know how many times defense attorneys have tried something that they didn't, quote, get away with. Whether it was reasonable or not, it's a question. I believe it was a reasonable, given all of those facts, given all of that testimony. It was not unreasonable. It was not unfathomable.
All right, Mr. Corianti, let me just briefly touch on some of the arguments made in the second half of their brief. Let me say that hypothetically, instead of an ineffective assistance of counsel cause of action, that Ms. Smithy had sued Mr. Jancha for legal malpractice. Would the testimony of another lawyer as to the performance by Mr. Jancha have been admissible?
Absolutely. I've been in that position before.
Okay, so if it's admissible in a cause of action for money damages, why wouldn't it be admissible when your freedom is on the line?
Well, it went to the, you have to judge, I think in these cases, you have to judge the attorney's performance by the facts of the case and hopefully his mental decision-making process or those who were involved with the trial. Outside counsel and outside judges and attorneys can weigh in on something like that, but they can't really help the judge make a determination about the facts of this case and the attorney. Fine, it's irrelevant in a criminal case what another police officer, for instance, would have done had he been there, and maybe he wouldn't have arrested the guy. That can't be brought in. So, I mean, as far as relevance, it has to be relevant to the issue at hand and to the case and the facts at hand, I believe.
You don't think that the testimony from a lawyer as to what a reasonable practitioner in the area would have done, doesn't have it doesn't tend to prove that which is an issue?
No, it doesn't prove the decision-making process that happened at the time, but it was proffered. Sorry.
Okay.
It was proffered below, and so we know what his testimony was. And it's not surprising for him to say that, because that's what he says. And I mean, then I can bring in experts, I suppose, and the state would at a hearing just bring in an argument of experts as to, well, it's reasonable or it's not reasonable. The fact that there is one more attorney on one side, to me, that's the civil and the preponderance of the evidence type of thing, rather than what we have in a criminal case, where we got to make sure that it's relevant to the facts in the case at hand and the person who handled that trial for 4 years.
So how do you then explain the vast number of cases where these experts have been allowed to testify?
It's a discretionary call by the trial court as to the facts. In this case, the trial court believed that it had, and it did, have enough evidence for it to determine whether or not, and we can read the trial court. He said, you guys have been going at this for 4 years. He put and I cited in my brief because it's important, but it was well fought. They scraped, they battled, they sparred, filing motions late, filing motions back and forth, taking pot shots at each other all the way through this trial. There was no surprise here. There was no other outside influence or attorney who could have opined on that entire process that this judge had reviewed, and that was in the record. And so, yes, could it have possibly been admitted? It could have, but the judge in his discretion, in her discretion, decided that it was not going to help her with the ultimate determination. And I don't know that it would help this court, because then all I'd argue is that what did he know other than compare their 4 years of defense counsel?
My question was more just as an evidentiary matter, does that testimony tend to prove an issue? Because that's the standard of relevancy.
That, I don't think it tends to prove anything here, what another attorney would have done who was not on the case. Mr. Belanger's testimony, who was in the case, seemed to indicate many things that were favorable to the state.
But ineffective assistance of counsel is gauged upon what a reasonable lawyer would or wouldn't have done, isn't it?
It is. But I mean, the facts are clear in this case as to what was done and why, as far as we know, why it was done. Mr. Yansha is no longer able to testify other than that affidavit that was mentioned, but they didn't believe that it was going to come in. Question is, based upon that, it's a simple question. And I think the court spent a lot of time going over it to come up with this determination, both on opening the door and on ruling that it wasn't an unreasonable decision given the facts and the evidence at the time.
It's a simple question. What does that mean?
It's a simple question as to whether or not this was reasonable or not, as far as with the facts of this case and what went on. The judge below, I don't think it's a difficult question. It's simply, did he have a reasonable chance of getting this in here without having the damaging evidence hurt him? And I think he did everything he could to protect himself from that in case he decided to use it. I think that evidence is clear.
Further questions? All right. Thank you, Mr. Coriante.
Thank you.
Mr. Ufferman?
Thank
You've
you.
got, I think, about 4 minutes or so. Oh, no, minute 32. I'll give you a little extra because you had to read my lips.
Thank you, Your Honor. May it please the court, I do submit that if Mr. Jancha in any way thought that her suppressed statements would be admitted, he would not have presented Dr. Anderson. He would have handled this very differently. Number one, an attorney in his situation should file a pretrial motion in limine and get a ruling from the judge ahead of time. Look, if I introduce this 911 call, is that going to lead to the introduction of the suppressed statements? Number two, you wouldn't put on someone like Dr. Anderson to say something completely different than what Ms. Smithy would say in her own statements, in her own words to law enforcement. You would put on an expert who would testify about why do people that have undergone this type of stress and trauma, why would they potentially either give a false confession about stabbing themselves, or why would they possibly stab themselves in the situation to make it seem like their story has to be believable, because women in these battered spouse situations often aren't believed. You would handle this much differently, but you would never put on someone like Dr. Anderson. And again, there's no way any reasonable attorney, from the opening the door concept, there is no case, there is no concept. The idea that you would mislead the jury and that would open the door to other evidence, this is clear-cut bar exam type information. If what was suppressed pre-trial is a statement that she stabbed herself, and you're going to introduce a statement that he stabbed me, there's no question that was going to come in. They didn't know that. Mr. Belanger himself even acknowledged on page 800, they didn't even discuss the possibility of the door being opened. How could they possibly, prior to introducing the 911 call, make an informed decision if they didn't understand what the law was? And therefore, I'd ask this court to reverse. Thank you.
Thank you, Mr. Efferman. Thank you for, we appreciate arguments on both sides, and we'll be in recess.